Hey everybody, Jeremy here. We're going to do another video today. It's going to be a good one for you, so stand by, stick around. I'm going to call it What They Don't Want You to See, Discovery in a Court Case. We're going to talk about that today. Discovery, that's one word every corrupt official fears. Because that's where the truth comes, actually, that's where the truth becomes evidence. It's the stage they cannot control. So, where every lie gets exposed, they can't control it. They don't want it to get that far. But it's going to. But before we get into this video today, there's a couple things here I want to show you guys. This here is the swearing in of Westmoreland Court of Common Pleas Judge Benoni in 2019, December 26th. This is Matthew Smidgy getting sworn in. Looks like February 11th, 2025, so just recently. That's my new, well, I don't know how long he's going to be on my case, but those two were on my case. The first one, the female, was the first one that was on the case, which has done a lot of things that she shouldn't have. And again, why I'm making this video is to let everybody know what comes of discovery, what happens, what you get to do, what you should do, what you go after. And man, I'll tell you what, when you file a lawsuit on somebody or people's, the first stage is getting through the motions to dismiss and all that stuff. So if you do your homework and put it together correctly, you shouldn't have anything to worry about. They're all going to plead to dismiss. They're all going to beg to dismiss for a bunch of million reasons. Most of it's technicalities, but not one of them will say I didn't do anything, so I'm dismissing on the merits of it. So anyhow, we're going to get into the discovery here a little bit and go from there. So Rule 26, Bravo 1 says discovery covers any non-privileged matter that could lead to admissible evidence in your court case. It doesn't have to be perfect for trial. It just has to matter to the truth. So that's why they're terrified. Because discovery opens their internal files, their communications, and their cover-ups. Everything. When you get to discovery, there is so much that you can get into. And I'll tell you what, it's a little bit early to talk about discovery in my case, but it's not too early. But I do have everything put together. I already have a binder that is probably 5 inches thick so far of what all I will be going after, looking for, getting. And I'm not going to put that on here, but I want to tell you guys that it's very intrinsic. It is very, it's surgical. And that's the only way I can put it. Because when you get the chance to get the discovery and it actually happens, you better have everything ready to go. Because there's a lot, especially in my case, I got a lot of people that are involved in my lawsuit. And you have to have everybody's stuff ready to go. You have to have your shit together before you start this. You don't want to look like an old fool when you go there. You get to do a bunch of stuff, depositions, and we'll get into that here. So, like, section 2 of this video is going to be called The Tools of Discovery. Here's what I'll be using in my federal case and what they'll be forced to answer. Interrogatories, rule number 33. Written questions. So just bear with me. I'm trying to think all this in my head. Written questions answered under oath. No dodging. No lying. That's interrogatories. Requests for production. I think it's rule 34. So I can demand every email, text, report, file connected to this case. from the DA's office to the judges to SPHS to all of them, everybody. Request for admissions, I think that's Rule 36. I wanted to do these in order. Rule 36 is request for admissions. They must admit or deny specific facts. Once admitted, it's binding. So they don't get to say, well, that's not what I meant or I didn't mean to say. Once you say something and admit to whatever it is that I'm asking, that's final. That's the answer. You don't get there's no takebacks. Request for production, Rule 34, I can demand every email, text and report and everything, and that goes with everybody. So that's a very important one there. That's one I'll be digging in because I must prove some other things. I have a lot of proof, documented evidence of just about everything from my case, but allowing discovery will absolutely open the door for me to really get this going and get what I want. And again, they hate that. They don't want you snooping around their private stuff per se. Depositions, I just told you guys about that, Rule 30. Face-to-face questionings, it's recorded under oath with the reporter recording every word. So I think probably a lot of you guys know what a deposition is and what it entails of. That's where you get to question them on camera and everything's recorded. Subpoenas, Rule 45. That's pulling evidence from third parties that aren't necessarily being sued, but they have an involvement and they may have information that I need, like Department of Human Services or PSP or county IT servers. Like, there's a lot of stuff. Again, I'm not going to spill the beans of what all I'm going to go after and what I already have put together, but I'm going to help you guys out. For those of you that are planning a lawsuit on somebody or a entity such as a family court, if they've done something wrong to you like this. Section 3, what they don't want me to see during discovery, and that's pretty much anything. But let's be real. The last thing they want is a paper trail under oath. That is the last thing. I'm talking about internal emails between the DA's office, SPHS, the state police, the CYS, domestic relations, judges, lawyers, so on and so forth. Case notes from the Children's Bureau showing that I was cleared. Nobody's ever mentioned that except for me. And when I do mention that I've been cleared through the CYS and the state police charges, nobody seems to care. So, case notes from Children's Bureau, that'll show everything, as I was just saying. That's very important. Anything showing that you're cleared of any accusations they had thrown at you, those are definitely big. SPHS, Southwestern Pennsylvania, Human Services, memos about falsifying therapy requirements. I went there under it was kind of an order to get the charges dismissed. Even though they should have been dismissed outright anyhow, I had to play a rigmarole game here with go get a drug and alcohol evaluation. They didn't bust me on drugs. They didn't catch me dealing drugs. They didn't catch me drunk driving. They didn't see me drinking anywhere or anything like that. But I was ordered to go do that because my son has a drug problem, but I'm responsible to go get a drug and alcohol. I mean, do you hear this shit? This makes no sense, but this is what they do to keep the money flowing through each one of their partners. And when I say partners, I'm talking the court. I'm talking a private behavioral health station here, such as SPHS, the CYS. It just all makes money and it makes the wheels go round and round. Judge Benoni's communications and orders after she was recused. We're gonna find out more about that. Attorney Emily Geiger's internal emails admitting there's no Title 4D application, and how do we handle this? In the county's insurance and bond records, tying directly into my RICO claims. Once discovery opens, guys, every one of those files is fair game. Every false statement becomes evidence. Section 4, why discovery terrifies them. Rule 26G requires attorneys to certify that their responses are truthful. If they lie or withhold, that's sanctionable and criminal. So you can't lie, and if you do, you're going to get caught. So I suggest anybody going through this, whether you're the defendant or plaintiff, don't lie. No matter what it looks like on you, how bad it may be, don't lie, because take it serious. Even though the court might lie and do it against you, two wrongs don't make a right. You have to go in there and be the upstanding American citizen, the parent, the father, the mother, whatever it may be. And don't lie, just tell the truth. The truth always comes out and will always win and prevail. You just have to get there, and it takes time, and you got to know how to do it. Under 18 U.S.C. Sections 1001, 1503, and 1519, that's perjury, obstruction, and falsifying records. Immunity won't protect them here. Once factual disputes exist, they have to produce the documents. Mitchell versus Forsyth, Harlow versus Fitzgerald. The courts have spoken. Discovery still happens when officials act outside the law. And when it comes to all this stuff, the law is on my side. The Supreme Court in Hickman versus Taylor called discovery the foundation of truth and justice. Rule 26B1 guarantees my right to obtain anything relevant to my claims. And I got 20 counts in there, guys. That's 20, pretty much 20 charges. Like, say if you got arrested and you did 20 different things, well, that's 20 counts. That's 20 charges. So I have 20 different counts against all these defendants here. So it's a lot. And it's not the first time somebody's brought a big lawsuit like this together against somebody or a corporation or whatever it may be. So it's nothing new. It just takes longer. You have to be very thorough at everything you do. And as a pro se litigant myself, I don't have a choice. I cannot find an attorney. I have tried to find an attorney to help assist me in the procedural aspect of it, because I don't want to screw nothing up. But at the same time, I can't get one given to me because I make too much, but I get a VA compensation from being disabled. So I'm kind of in that gray area where I can't afford one. I make too much to get a pro bono one, and nobody wants to take this anyhow unless they would be from out of state, because they work and know these people that I'm suing, and they're not going to go against them. So that's why I'm doing it myself, pro se. It's not because I'm better than anybody. It's not because I think I'm smarter than anybody. It's because nobody will take the case, for number one. Number two, I cannot afford it. I'm a disabled veteran. I'm in and out of court all the time with contempt hearings and conferences and all that, because I'm struggling to pay anything. And I shouldn't have to pay nothing to this domestic relations office with all the violations and disgusting fraud that they've committed. And yes, I got piles of documented evidence, everything they did. Guys, the case has been shut down. On an official Pacey's record, which is an official court document that the state of Pennsylvania uses, the third or fourth entry, 3 months after the complaint was filed, it was terminated, withdrawn, and dismissed. So anything they've done after that is actually illegal, and they've done a lot. And, when this trial kicks off, man, I'll tell you what, I can't wait to get the discovery. I am chomping at the bit, jonesing to get the discovery, because everybody in my suit got something coming to them. And I got something for all these people, on all these people. Not just something. I got a lot of things on a lot of people in my case. So it's a lot of work. So they can hide behind immunity. They can stall with motions, but when discovery hits, the paper trail does not lie. That's why I'm fighting, because the truth is coming and they know it. They're watching my pages. They're trying to see what all I got on them, but I'm not that stupid. Yes, I have shown some things in my case, but I'm going to tell you guys right now, those are just a couple very minor things that I got on these people. And whenever discovery kicks off and cracks open, man, they should have considered taking my offer when I offered an early settlement proposal to everybody. These attorneys, the counsel for the defendants, I don't think are really doing them any justice, because I don't think that they realize that I'm somebody that's not going to quit, that ain't just going to go away. I'm not going to shut up. I'm not going to get frustrated and just say, the hell with it, I'm done. I'm not getting nowhere. Well, I know I wasn't going to get anywhere in family court, Westmoreland court. But you have to document a pattern. You have to document the behaviors. You have to document everything that happens. And that's what I've done. It took time. I legitimately tried to do all I can to get my children back and to get all this stuff settled between myself and this court, but they don't want to play. They don't want to play ball. So that's fine. This is the route I had to go, the federal lawsuit. And also, I actually got in the door to Superior Court with an appeal for a motion that was denied that I filed. And I'm glad it was denied. It was a blessing in disguise. You know why? Because now it's getting appealed to Superior Court, which is a higher court. And once that door opens, which it has, they accepted my appeal, I will be firing off every other single thing that I have in my federal suit. They're going to know everything too, and they're going to probably go bonkers. They're going to lose their mind when they see all the stuff that this court has done to me. And I'm going to let them know that it's going on with a lot of other people too. And I have been in contact with a lot of these other people that have similar issues, if not worse than mine. They're no longer sitting silent. I'll never be silent. This is what I have to do. This is my fight, and I'm going to win it. I'm not here to lose. I didn't come in here just to get walked all over and give up and get frustrated and say, well, I'm done. You guys won't give me no remedy, so I'm going to quit. I'm going to walk away and go to the bar and drink myself to death. You guys should have did your homework on me long before you did this. So anyhow, I hope this video was good for you guys. It gives you a little information on what to look forward to when you file a lawsuit and you get to discovery. That's your bread and butter. That's going to hold these people accountable. And, you guys don't sit down and take it no more. Everybody needs to stop this shit of just giving up, getting tired. I know it's hard, frustrating. It's emotionally draining. It's mentally draining. Physically, it's all the above. But is the fight worth it to you? Is your freedom, your rights, your children? I would think that would be worth it to everybody that's fighting this kind of corruption and behavior from our family courts. We're not going to take it no more. Believe me, we're not. And it starts now. It started with me. And I'll be glad to be the leader of this movement if I have to. I don't want to, but if I have to, it'll just be another thing on my plate that I can handle. So here we go. Thank you guys for watching the video today. I hope it helped you out. We're going to start doing some more informational videos on different processes of lawsuits, and also how to get started on things such as, getting all your records from the child support office, getting all your records from the court case, from the prothonotary, and find out what all they did wrong, what rights were violated, and what laws were broken, what rules were broken from the judges, and et cetera, and so on and so forth. We're going to get all of that. I'm very busy. I'm trying to make videos as much as I can. So stay tuned, and you guys have a good rest of the week. Take care.